Unspoken Legal Theory. Thank you to all returning subscribers, and to all those who are new here, please consider subscribing and recommending JurisQuestHub to someone today. Your support enables us to continue providing valuable content on jurisprudence and legal theory. I'm your host, Cynthia Liavule, and let's get started on today's episode. If you recall, our series Shapers of Natural Law Theory focused on one of the most influential theories on explaining what the law is, based on two major foundations: objective universal principles on the nature of law, which are discoverable through human reason, and its interconnectedness to human morality. This, of course, is accompanied with elements such as the common good. And from natural law theory, we saw law as an extension of human reason. Today we start on legal positivism, which started largely as a response to critique natural law theory, but developed its own framework to explain what the law is. First, let's start with the term legal positivism, which comes from the idea that law is posited, and posit from Latin, which means created or laid down, enacted, or established. In this case, established by human beings rather than derived from morality, nature, or divine authority. So the word positive in legal positivism does not mean good, beneficial, or optimistic. It derives from the Latin positus, which means to place or to lay down. And therefore, it refers to law as that which has been deliberately established by recognized authority. So legal positivists, among whom some photos you can see on your screen, Thomas Hobbes, Bentham, John Austin, and Hans Kelsen, argue that the law exists because it has been posited, it has been made or enacted by human institutions. So the validity of law depends on social factors such as legislation, judicial decisions, customs, or even constitutional procedures. And this can be contrasted against natural law theorists who argue that the law derives its authority, at least in part, from moral principles. So legal positivists in general maintain that legal validity depends on its source, not on its moral content. So we are going to begin by attempting to trace the intellectual origins of legal positivism and its evolution over time. And notable proponents and theories associated with early positivism, otherwise referred to as classical positivism, include Thomas Hobbes, John Austin, Bentham, Hans Kelsen, and of course later on we're going to look at other analytical legal positivists, including H.L. Hart, whom we've looked at before in our previous episodes. We will go through their specific contributions in coming episodes of this series on legal positivism. But this is just the beginning, and therefore it's a beginner's guide so that we just get a general overview of what legal positivism is. So I could summarize my perspective of legal positivism as not a single doctrine created by one thinker, but rather a jurisprudential tradition that developed progressively through the contribution of several scholars who shared the belief that law derives its validity from human authority and social factors rather than morality, religion, or natural justice, which we saw influenced a lot the propositions by many natural law proponents. So I think legal positivism major influence was felt in the exercise of political authority and the tendency toward utilitarianism, as we have seen in our previous episodes, especially during, for example, the Nazi period. And it was basically used as a tool to attain an end, which is very distinct from the approach of natural law theory. So before delving further, I just wanted us to look at a little analogy, using the analogy of, let's say, the legitimacy of a currency, so that we're able to explain what the thought framework of legal positivism is. So imagine a government prints a new currency, a banknote, let's say. So a legal positivist would ask, did it come from an authorized central bank? Yeah. So that they confirm the legitimacy of that currency. If the answer is yes, then the inquiry is complete. The source confers its legal status as currency. But the natural law theorists will ask two questions. Did it come from the authorized central bank? And does it serve the proper ends for which that currency exists within a just society? So for the natural law theorists, the source is necessary but not sufficient, and therefore they apply it to the law. So the positivist will just trace the law to its legal source, but the natural law theorists will trace the law to its legal source and then evaluate it against higher principles of justice and reason. Yeah. So we see an extension of the source, of seeking the source of law. So like I mentioned, it's an evolving intellectual tradition, and if you look at the slide, those are some of the what would refer to as a classical legal positivists during the different centuries, especially during the 17th, 18th, 19th, and 20th century. And they basically affirm the fact that the law is based on authority and social facts rather than morality. So let us look at our first proponent of legal positivism. We could start with Thomas Hobbes, and the historical foundation of legal positivism, you could say, begins with Thomas Hobbes in the 17th century. Although he was a political theorist, he laid the groundwork for positivist thought by emphasizing the necessity of a sovereign authority to maintain social order. So in his political theory, law is understood as the command of a sovereign whose authority arose from a social contract established to escape the chaos of the state of nature. So according to him, human nature is chaotic, and therefore in order to maintain order, we establish a social contract, and therefore we have a sovereign who commands authority in order to ensure that there is order. So the validity of law depended on its source in sovereign authority rather than on conformity to moral principles. So he introduced one of the central ideas of legal positivism, that law is fundamentally a human institution created to secure political stability. Then from Hobbes, in the 18th century, the next major step, you could say, in the development of legal positivism emerged in the work of Jeremy Bentham, whose contributions were huge. He was the first systematic critic of natural theory, and he rejected the notion that legal rights and obligations originated from natural or divine sources. Yeah, so his critique was basically natural rights lack an objective foundation. So he argued that the law should be viewed as a product of legislative authority. So while he believed that laws should promote the greatest happiness of the greatest number, like Aristotle, for example, he insisted that the question of whether a law is valid must be distinguished from whether it is morally desirable. So for him, what becomes a marking feature is the law is as is rather than as what it ought to be. And this distinction became one of the defining features of legal positivism. So through Bentham, positivism developed into a more analytical and a secular approach to law that sought to separate legal science from moral philosophy. So like we see, there's growth, one proponent building on the propositions of the other and so forth, and therefore, moving towards a theoretical framework. Then we have John Austin, whose contributions were also major because of what he came up or formulated, known as the common theory of law. So legal positivism reached its classical formulation in the 19th century through the work of John Austin. So Austin transformed Bentham's ideas into a comprehensive theory known as the common theory of law. So according to Austin, law consists of commands issued by a sovereign and enforced through sanction. So what this means is that a law is valid because it emanates from a political superior who is habitually obeyed by society. So the existence of law is entirely separate from its moral merit. And his famous proposition is that the existence of law is one thing, its merit or demerit is another, because the clearest expression of and which becomes then the clearest expression of the positivist separation thesis. They are separating morality from law. So Austin's work is the most influential statement of classical legal positivism because it provided a precise criterion for identifying law based on authority rather than morality. And later on, as we look at John Austin's arguments, we'll realize that this command theory faced a lot of difficulties in explaining increasingly complex legal systems, especially constitutional rules, judicial powers, legal institutions. They could not always be adequately understood as sovereign commands, backed by sanctions. And therefore, in the 20th century, there were positivists who then sought to refine and modernize the command theory of law. Then one of the most remarkable legal positivists in the 20th century is Hans Kelsen, and his most important development, came through the work of his work where he rejected Austin's emphasis on commands and instead viewed law as a hierarchy of norms. So he formulated what is known as the pure theory of law, which we will look at in detail in our next episodes, which hopefully we shall name Shapers of Legal Positivism. So in his pure theory of law, each legal rule derives its validity from a higher legal norm until the system ultimately rests upon a presupposed fundamental norm. So you have one, then another at the top, another, and then finally we have a fundamental norm, which now he referred to as the grand norm. So through Kelsen, legal positivism evolved from a theory of sovereign power into a theory of normative legal systems. And this development was a major advance because it allowed positivism then to explain things like the place of constitutions in terms of constitutionalism, then judicial review, and then also it helped a lot in complex modern systems without abandoning its commitment to separating law from morality. And we can see that is a cross-cutting thread among these theories that we have named. So some of the cross-cutting themes among legal positivism then can be viewed as that the validity of law depends upon its social source rather than its moral content. So whether a law is just or unjust is a separate question from whether it is legally valid. Then the second argument is that law is a human creation established through political and legal institutions rather than through divine command or natural reason. Like I mentioned before, most of legal positivism started as a criticism of natural law theory, existence of universal principles and objective principles that are universally accepted by all. So here we see that law is a human creation established through political and legal institutions rather than a divine command or natural reason. Then the third argument is that legal analysis should focus on identifying and describing existing law objectively before engaging in moral evaluation, which goes basically to also emphasize that separation of law from morality. And the last argument is that although there is separation of law and morality, legal positivism, of course, which we'll debate later on a little bit about, it doesn't prevent criticism of unjust laws. Rather, it allows such criticism to be conducted with conceptual clarity by distinguishing legal validity from moral legitimacy. So I leave it. Then legal positivism can be described as a historical movement that progressively refined its understanding of legal validity while preserving its foundational principle that law and morality are conceptually distinct. And this historical narrative helps explain why legal positivism became one of the most dominant traditions in modern jurisprudence, and has actually in fact laid the foundation for later developments, including the work of H.L. Hart and other contemporary analytical legal theorists. And from the slide you can see that those are some of the core principles of legal positivism. The source thesis, the human creation, the descriptive approach, the separation thesis, and the criticism, like we mentioned before. So legal positivism can also be portrayed as an evolving intellectual tradition, characterized by continuity, just like natural law theory was, if you go back to our previous episodes, characterized by continuity and adaptation. From Hobbes' theory of sovereign authority, and then now we move on to Bentham's critique of natural law. Then Austin provides an alternative through the command theory. Then Kelsen provides normative legal systems. The central positivist commitment remains the same, that law is valid because it originates from a recognized legal authority and established social institutions, not because it embodies morality. So I think that will be our guiding thread as we continue to analyze legal positivism. So that brings us to the end of today's episode and the general beginner's guide to legal positivism, which of course marks the start of another set of refreshing series on the shapers of legal positivism. If you learned something today, please feel free to share your thoughts using the details shared on the screen. And don't forget to like, to subscribe, and hit the notification button for our next episode. See you then, and thank you for keeping it here at JurisQuestHub.